Start. This provision thus make a few things clear. Firstly, the power to extend the mandate of an arbitrator under subsection 4 of section 29A beyond the period of 12 months or such further period. It may have been extended in terms of subsection 3 of section 29A rests with the court. Neither the arbitrator nor the parties, even by joint consent, can extend such period. The court, on the other hand, has vast powers for extension of the period even after such period is over. While doing so, the court could also choose to substitute one or all of the arbitrators, and this is where the definition of term court contained in section 2 does not fit. It is inconceivable that the legislature would vest the power in the principal judge to substitute an arbitrator who may have been appointed by the High Court or Supreme Court. Even otherwise, it would be wholly impermissible since the powers for appointment of an arbitrator when the situation so arises vest in the High Court or the Supreme Court as the case may be in terms of subsection 4, 5, and 6 of section 11 of the Act. If therefore there is a case for extension of the term of an arbitrator who has been appointed by the High Court or Supreme Court, and if the contention of Sri Mehta that such an application would lie only before the principal civil court is upheld, powers under subsection 6 of section 29A would be non operatable. In such a situation, subsection 6 of section 29A would be rendered. The powers under subsection 6 of section 29A are of considerable significance. The powers for extending the mandate of an arbitrator are coupled with the power to substitute an arbitrator. These powers of substitution of an arbitrator are thus to the principal powers for granting an extension. If, for valid reasons, the court finds that it is a fit case for extending the mandate of the arbitrator, but that by itself may not be sufficient to bring about an early end to the arbitral proceedings, the court may also consider substituting the existing arbitrator. It would be wholly incumbent to hold that under subsection 6 of section 29A, the legislature has vested powers in the civil court to make appointment of arbitrators by substituting an arbitrator or the whole panel of arbitrators appointed by the High Court. Under section 11 of the Act, if we therefore accept the contention of Sri Mehta, it would lead to conflict between the power of the superior courts to appoint arbitrators under section 11 of the Act and those of the civil court to substitute such arbitrators under section 29A. This conflict can be avoided only by understanding the term court for the purpose of section 29A as the court which appointed the arbitrator in case of court constituted arbitral tribunal. Very similar situation would arise in case of an international commercial arbitration where the power to make an appointment of an arbitrator in terms of section 11 vests exclusively with the Supreme Court. In terms of section 2, the court in such case would be the High Court, either exercising original jurisdiction or appellate jurisdiction. Even in such a case, if the High Court were to exercise power of substitution of an arbitrator, it would be transgressing its jurisdiction since the power to appoint an arbitrator in an international commercial arbitrator rests